In this video, we're going to talk about trademark notice and trademark registration. Now, we've already talked about you don't have to register your mark in order to have trademark rights. You can merely use the mark in commerce as a way of identifying the source of your goods or services. But there are advantages to registering your mark. Prior to registering your mark, to tell the world you're using your mark as a trademark, you can mark it with the TM symbol or an SM symbol for a service mark. That's if your mark is associated with a service as compared to a product. Once you've registered your mark, then you can use the R with a circle around it as a notice to the world that your mark is in fact registered at the U.S. Patent and Trademark Office. Now, prior to registering your mark at the U.S. Patent and Trademark Office, when you're using your mark as a trademark, you will establish rights in the particular geography where you're actually using your mark as a trademark. So, if you're using your mark only in California, theoretically, someone else could start using the same mark in association with the same goods or services in New York, and they would establish trademark rights in their particular geography. You could build out your brand, but you'd probably never be able to enter New York without getting permission from the prior user in New York. That shows us one of the huge advantages of registering your trademark. Registering your trademark counts as constructive use nationwide. So even if you're only using your mark in a particular geography, like on the West Coast, if you register your mark at the U.S. Patent and Trademark Office, it counts as if you used your mark as a trademark nationwide, and you defeat any subsequent user, even in a geography in which you haven't entered. Now let's talk more about the registration process. There's two different ways to apply for a trademark. One is based upon your actual use of the mark in commerce. The other is based upon what's called a bona fide intent to use. With an intent to use application, you haven't actually used the mark yet, but you can file an intent to use application, and you have 6 months to file a statement of actual use with the Patent and Trademark Office. You can file an extension up to 5 times. So in effect, you have up to 3 years to actually use your mark in commerce, and you'll get priority for your registration dating back to the date you filed the intent to use application. Once you've filed your application, an examiner at the Trademark Office is going to review it. They're going to make sure you've included the necessary information in your application, including a description of the particular goods or services with which you're going to use the mark as a brand identifier. They're going to check prior registrations to make sure your mark isn't confusingly similar with any existing registration or registered mark. Now note, the examiner is not going to check prior unregistered marks. So it's possible that you could obtain registration on your mark, but there still could be a prior user of an unregistered mark that your mark would still have to defer to. Once they reviewed your application and found that it's not confusingly similar to any prior registered mark, they are going to post your mark on the official Gazette. Your mark will be on the official Gazette for 30 days. Third parties then, who often monitor the official Gazette, have a chance to file what's called an opposition. If no opposition is filed within 30 days, you will obtain your official registration. And that's a very general overview of the trademark registration and notice process.